And welcome to a special town hall meeting. I am your co-host, Khari Mosley from One Hood Power, and I am here with the president, CEO, co-founder, and woman about town celebrity all-star, Brandi Fisher from APA. Welcome, welcome. Great to be here doing this special town hall with you this evening.
Yes, good evening, everyone. Thank you, Khari.
Yeah, well, thank you so much for joining us, and we're here for very important issue. This is the Juvenile Justice Commission Task Force Town Hall. We are going to be talking about a whole range of issues around the governor's juvenile task force. That you're going to learn so much information from our all-star panel. I'm just going to give you a quick sneak preview of who's going to be joining us tonight. We have Tiffany Sysmar from Duquesne University, Leola Hardy from the Defenders Association of Philadelphia, Gada Makushi from the American Civil Liberties Union, as well as Cheryl Kleiman Esquire from the Education Law Center. And they will all be talking about specific aspects of the juvenile task force that the governor created about a year ago. But before we go into that, we do have two very important calls to action that myself and Brandi will be talking about. On April 14th, there'll be a very important convening of this commission, and the public has an opportunity to have their voice heard. So Brandi, could you talk a little bit about the ways that people can have their voice heard around this really important matter?
Yes, of course, absolutely. And that was one of the reasons we felt so urgently to put this on today, is because you have to register by this Thursday, April 8th, by 5 o'clock in order to testify on April 14th. And so tonight, you might say, testify about what? What am I going to talk about? There have been a group of people working for an entire year on these recommendations, from advocates to the DA's offices across the state, parole and probation. A lot of people have been working on this, and these recommendations have been slated to come out a couple of times, and the date keeps getting pushed back. And one of the reasons they stated that they wanted to push this back is because they wanted another date after they closed it for public comment. And so we want to make sure that your voices have the opportunity to be heard, especially after a year long. And a lot of people were not aware of this. And tonight we're going to also provide the opportunity for you to become educated, not only by people who have been working in this field for a long time, but some people who have actually sat on this task force for the past year. And so we'll be dropping that information in the chat, a link for you to be able to sign up to do public comment on the 14th, but you have to sign up by this Thursday by 5 o'clock.
Absolutely. And that's why this issue is so timely. And now we're going to do some quick introductions with our all-star panel. We're so excited to have them joining us. So starting with the introductions, our first panelist, Tiffany Sysmar from the Duquesne University School of Law. Welcome.
Thank you so much. It's great to be here. As both Brandi and Khari just stated, the task force is currently wrapping up its work. I'm a member of the task force, and I've been there since the beginning, December of 2019, when the governor appointed the members. We have many members, attorneys, judges, legislators from both sides of the aisle in Pennsylvania, people from the Department of Human Services, from the Education, State Department of Education, placement providers, victims advocates, etc. There are 30 or so members of the task force, and we are wrapping up our work, but there will be one final comment period date on April 14th. But as Brandi said, we must have people sign up by April 8th to speak at that meeting, which is will be the focus of our town hall here tonight. Other than being on the task force, I am a clinical professor at Duquesne University School of Law. I operate a legal clinic that is focused on helping young people in the delinquency system and in the school education and special education and school discipline systems. And so the work that is associated with the task force is the work that myself and all of the other panelists are immersed in daily. And so I'm really happy to be here, and I hope to be able to share with you a little bit about what's been going on within the task force up to this point.
Thank you so much. Thank you for joining us. And I want to introduce our next panelist, Leola Hardy from the Defenders Association of Philadelphia. Welcome.
You're on mute, Leola.
Yeah, Leola on mute.
Of course, I'm the first one to make a mistake.
No problem. Welcome.
Thank you. I want to say thank you to Brandi and Khari for inviting me this evening to speak on this panel. I am really, really passionate about changes to juvenile justice and treating children like children. I am the chief of the Children and Youth Justice Unit at the Defender Association of Philadelphia. A little bit about myself. I've been a public defender for all of my legal career for 23 years. I have been chief of what used to be called the Juvenile Unit at the Defender Association of Philadelphia for the past 4 years. I say what used to be called the Juvenile Unit. I would just like to say that I feel like words matter, and we can never forget that when we're talking about children. We're not just talking about juveniles, because in so many instances, the lexicon, the language that's used within the juvenile justice system is just so sanitized that we forget that we're talking about young people and not little adults who are coming through the system. I was on a panel of returning citizens who have been sentenced to juvenile life without parole. As we know now, the Supreme Court of the United States has said that that is unconstitutional and cruel and unusual punishment to sentence children to life in prison. But one of the things that really resounded with me from one of the returning citizens who spoke is that he felt the one thing that was missing with what happened to him and how he's ended up spending 30 years in prison for something that happened when he was a teenager was that they forgot that he was a child. And I never want any of us to forget that when we're talking about juvenile justice, when we're talking about these possible legislative changes or recommendations, we're talking about our future and we're talking about children. So I'm very, very excited to share my knowledge and my passion for juvenile justice and change with everyone today. Some of the two things that are really, really important to me and I really want to highlight this evening. One is to raise the age of jurisdiction for kids in Pennsylvania. Right now, you can be as young as 10 years old and be arrested and charged and have to go through a trial and possibly be placed somewhere. And number two, to stop the charging of children as adults because they just are not adults. And lastly, and I'm going to pass it on, is I really want us to remember why we are all here, that there's been so much tragedy and abuse within the current juvenile justice system, not just here in Pennsylvania, but around the country. And we really need to reimagine what we consider justice. And so it's critical that everyone look at these recommendations and sign up to speak so that your voice can be heard. And I especially say that to young people who have been in the system. Please sign up so you can share your voice about what is going on and what happened. Thank you.
Absolutely not. Thank you so much. And that's a great way, to center, the conversation as we go to our next panelist, Gada Makushi from the American Civil Liberties Union. Welcome.
Thank you. Thanks for having me on. I'm kind of wearing two hats today. So yes, I am a community advocate with the ACLU, working on school policing issues, primarily in Allegheny County. I'm also a parent advocate with One Pennsylvania, which has been pushing Pittsburgh Public Schools for police-free schools lately. As far as the recommendations from the task force, a lot of the work that we do at the ACLU involves, fines and fees, which is recommendation 10, failure to comply, recommendation 11, and limiting arrests at schools as well as pre-diversion programs. And so many of us know that with regard to fines and fees, which are issued either at the court level or through the magistrate, there's no question that court-imposed financial obligations are a significant burden on youth and they are the largest driver of youth interactions with the juvenile justice system. They are the single biggest reasons that juveniles are referred to the juvenile justice system. Assessing unaffordable fines and fees on children leads to worse outcomes, both for the child and for their community. And we all have an interest in helping to rehabilitate children who commit offenses, but unaffordable financial obligations perversely increase the risk of recidivism, and they needlessly increase contact between juveniles and the juvenile justice system. As far as limiting arrests and court referrals for minor or other misdemeanors, we know that many of these infractions can be dealt with at the school level. They don't require juvenile justice system involvement. And I'll talk a little bit more about the pre-arrest diversion program, but schools can implement programs that support youth and their families to find out what services that they need, to offer them information about things that can support them. Kids are still learning, they're growing, they're processing, and they'll make mistakes, especially as teenagers. So we have an opportunity to help support children. Involvement in the juvenile justice system for minor offenses, as stated, doesn't just harm that child, doesn't just harm that family. It has an impact on the larger community, socially, economically. We can do better, and we should do better. And I will pass it on to the next presenter.
Thank you so much. And now we're going to bring our final panelist this evening, Cheryl Kleiman, Esquire from the Education Law Center. Welcome to the discussion.
Thank you. Thank you so much for having me. Great to be here.
Great. Yeah, would you like to just share a few words before we go into our longer presentations, just about your role, with the commission and the area that you're really focused on?
Yes, I am a civil rights attorney with the Education Law Center. We are a nonprofit law firm in Pennsylvania whose mission is to ensure that all children have access to a quality public education. I started my legal career representing young people who age out of the foster care and juvenile justice systems, and for the past 7 years have been working with the Education Law Center and fighting for education justice here in Pittsburgh and throughout Pennsylvania. Much of my work is really around trying to prevent children from ever getting involved in the juvenile justice system to begin with. Particularly, as Gada just talked about, the role of schools in pushing children out of school and into the carceral systems is just something that we need to start much earlier. And so a lot of my work is around trying to support community-led transformative change of school cultures and climates, to get school police out of schools so that we can dismantle the pathways to push out that are impacting Black and Brown children, students with disabilities, and LGBTQ folks. So in addition to preventing children's place in juvenile justice facilities, once they are there, our work is to ensure that they still have access to a quality public education. And then when they return from placement, can quickly return to the public school and not get pushed into these segregated inferior settings that we know happens all too often. And those are some of the issues that we're encouraging the task force and would love for our community partners to help lift up.
Thank you so much for that. And before we go into our longer presentations, we do want to remind everyone and those who are just joining us that this is a special town hall edition, One Hood Power, APA, 1PA, focusing on the Juvenile Justice Task Force with our all-star panel. We're also reminding people that if you want to speak at the April 14th convening of the task force, you must do so by this Thursday, and written comments can be made up until Monday, April 12th. So now we're going to our first presentation to give us some context and some background about the commission and the task force. And we have from Duquesne University Law School, Tiffany Sysmar.
Thank you. So the governor convened this task force in December 2019. We had our first meeting just before COVID. And then just like everyone else, we've been remote since then. And one of the things I always say that's a silver lining about that is it made the meetings much more accessible to the public. All of the task force meetings are public. At the time of the meeting, you can click onto the task force website and you can log in and you can watch and listen to the meetings. You can comment. But I just want to give folks a little bit of information about the process up to this point. The task force is convened by the Pew Foundation, or Pew Charitable Trust. So at the beginning of the process, what we did as task force members was we listened to data about Pennsylvania's juvenile legal system. We listened to data about racial and ethnic disparities. We listened to data about who's getting arrested, what they're being arrested for, what children are being adjudicated delinquent of, how many children are being placed outside their home, for how long, and all sorts of a really deep dive into the Pennsylvania juvenile legal system data. We even broke it down by county, and all of those presentations are available on the task force website. The slides can be viewed. The county by county data can be viewed for Allegheny County and any other county around the state. So I encourage people to check that out. After, and we heard from experts in the relevant subject areas. After that, we broke out into subgroups to begin to work on these recommendations. But before we broke out into subgroups, or at the same time, really, there was a process going on of convening stakeholder roundtables. So we heard from children from around the state. This part was not public. It was any member of the task force could attend a roundtable, but we convened children, parents, again, placement providers, district attorneys, defense attorneys, victims advocates, anybody you could think of, probation officers who touched the system. We convened stakeholder roundtables, and the task force, any member of the task force could attend any of those roundtables. And we listened to people tell us what works, what doesn't work, what changes they would like to see, what things they would like to stay the same in the system. We also had time for public comment after most of our public meetings. So we left, I think, an hour or so after every public meeting for people to come and comment. So following our subgroup process, what we all understood was to happen was that we would come back together as a larger task force, we would review our subgroup recommendations, and we would finalize our report to the governor by the end of March or early April, so that the legislature could begin to take action in the 21-22 legislative session on the recommendations. And what happened when we got back from our subgroups was that the recommendations caused significant conversation and some conflict on the task force. Again, these are public meetings that people were able to hear these conversations and disagreements about whether we should move forward with some of these recommendations and how we should move forward on them, whether things should be recommended as legislative changes or whether things should just be recommended as suggestions for how to improve the task force. And as a result of that conversation amongst members, it was decided that we would have one additional meeting where we allowed public comment. And this is truly the last opportunity for public comment. April 14th, sign up by April 8th at 5 p.m. You can also submit written testimony to the task force by Monday, April 12th. We receive emails from organizations all the time. We have received emails from individuals to the task force. Again, the task force membership is listed on the website. So every single one of us is reachable. But we have strong reason to believe that there will be significant dissent from the District Attorneys Association to some of the more progressive recommendations, including raising the minimum age of juvenile court jurisdiction, which Leola will discuss, ending direct file, which Leola will discuss, bringing Philadelphia's school diversion program into the legislature, and ending arrests for misdemeanors and some early offense, minor offenses altogether, as well as limiting the amount of time that children can be placed outside of their home, and limiting the amount of time in circumstances under which children can be held in pretrial detention. Those have been the recommendations that have been sort of the most contentious. And so it is really, really urgent that those of you who are listening and watching who have really been affected by the system to come to this meeting and to speak. Other young people and other parents have come and they have spoken out forcefully about their experiences. And it is important that the task force continue to hear your voices and continue to learn and understand that the harm that detention and out-of-home placement and charging children as adults does to our communities, to our families. And so I really just want to urge you to please speak out. My understanding is that we are going to issue a report no matter what, and that if we are not able to reach consensus on all recommendations, then the recommendations will be listed in the report as consensus recommendations, majority recommendations, and minority or less than majority recommendations. And so we really want all of these recommendations that are geared toward pushing kids out of the system and reducing racial and ethnic disparities to, at the very least, be majority recommendations, if not consensus recommendations, so that it is clear to Governor Wolf and to the rest of the legislature that this is truly what is best for children and the voice of the community. And if there's a vocal minority, so be it. But we're asking people to help this task force, push this task force onto the side of the children.
Thank you so much for that, Tiffany. And I just want to echo and remind people, as Leola pointed out in the beginning, and Tiffany just stated, that we are talking about children. And, you know, and I think the sense of urgency is just wrapped up in that statement. We're really talking about children. And we know as adults, we don't always make the best decisions, but we're talking about, you know, developmentally, scientifically proven that children who are not at the age to even make the best decisions, or sometimes not even able to. But we also know in the juvenile legal system, or in the criminal legal system, period, that there's a lot of disproportionality that exists. And so, Tiffany, I just want to ask you a very direct question about the recommendations. Have any of them specifically intended to address the disparate impact that Pennsylvania's youth sentencing practices have had, and other aspects of the state's juvenile justice system have had on youth of color in particular, both in Allegheny County and statewide?
Yeah, so I would say the ones that are primarily focused on that are the expanding and standardizing Philadelphia school-based diversion program, ending arrests or finding community alternatives to arrest for low-level offenses, raising the age, of course, and then probably the most profound one would be ending direct file. And so let me just stop on ending direct file for 1 second, although I know Leola will talk about this. This will not actually, much to my disappointment, end the practice of charging children as adults in Pennsylvania. But what it will do is ensure that any child who is arrested starts in juvenile court, and that if there is an attempt to remove them to criminal court, that those hearings happen in juvenile court, and that those children are held in juvenile detention to the extent that they need to be held pending the outcome of that hearing. So I just want to be clear, because that's something I think that people may try to oppose and say, well, I don't know if I think that no kid should ever be charged as an adult. I think no kid should ever be charged as an adult, but this does not end this practice. It moves the forum to juvenile court.
Thank you so much for that clarification. And Leola, could you expound on direct file just so people understand exactly what that means and the implications follow that?
Yes, Brandi, of course. So when Tiffany says direct file, what that means is the way the law stands today. Well, actually, it wasn't always like this, but as of 1996, the legislature in Pennsylvania decided to enumerate certain offenses that if you are 15 years old or older, between 15 and 18, you are not within the jurisdiction of the juvenile court or the Juvenile Act. And that means that if you're charged with certain felonies of the first degree, with what they consider a deadly weapon, and we can get into that in more detail later. That deadly weapon is not necessarily what we all think about deadly weapon. That definition is very expansive. It can be a brick, it can be a rock, all sorts of things. You are automatically charged as an adult. So your case starts in adult court. That means you are booked as an adult. You were given a bail hearing as an adult. You have bail set for you as if you are an adult. And you are held in an adult jail in Philadelphia. You are not in the same, your sight and sound separated from adults, but you're not held in our juvenile detention center. The burden is on you to go back to the juvenile system. So a judge has to make a determination whether you can go back to the juvenile system, whether you're amenable to that system and your needs can be met in that system. What Tiffany is talking about is shifting that. Instead of having cases start in the adult system, they would all start in the juvenile system. And then the burden would shift. There would have to be evidence that you cannot be dealt with or your needs cannot be met, your rehabilitative needs cannot be met within the juvenile system. And I think that is really, really key, that we have kids who are getting exorbitant bails, are waiting for their trials for years, just have a trial. What if a kid is not guilty, right? I mean, aren't we guilty before proven, innocent before being proven guilty? I said that because a lot of people do think people are guilty before they're proven innocent, but they're innocent. These are children who are being tried as an adult in adult court, and then have to prove that they're able to go back to juvenile court. So this just shifts the burden. I, like Tiffany, I do not believe that any child should be treated in the same manner as an adult and should not have to deal with adult consequences of certain behaviors. And that does not mean that I believe that children should not be held accountable. I just think that what we know about brain development should enlighten us in how we rehabilitate and we treat children so that they can go on and at some point move past this to be productive citizens. So it just shifts things. So I don't necessarily think this goes far enough, but at least it's a start that we can go back to pre-1996. 1996, the 90s, we all know about some of the really, really draconian laws that came into place in the 90s when it came to what they consider criminal justice, and which we see now as criminal injustice. So this was part of that in this idea of getting tough on crime, and we see where that has gotten us. You know, this being tough on crime has not eliminated crime. It has not made the world a better place. And we really need to use science and follow science and be more enlightened in how we look at things and how we deal with things.
Thank you so much for that. And for our next presentation, we have Gada Nkushi from the American Civil Liberties Union talking about ending most school-based prosecutions, removing fines and fees, and ending magistrate referrals to juvenile court.
Thank you. So I think one of the things I wanted to address is, there are a number of alternatives to addressing school conduct issues that don't involve the police and either arresting students or issuing summary citations. But before I say that, I want to start by saying that most of the issues that students receive a citation for or arrest are usually minor or typical adolescent behavior, things like obscene gesture or language, unreasonable noise, disorderly conduct. And disorderly conduct, I'll pause on that one and say that that one is highly subjective. Over 80% of disorderly conduct are issued to Black youth. It's where you, I'll talk about that a little bit more here. But so minor offenses like disorderly conduct, possession of a small amount of marijuana. And we know from research that it's not that a certain group of youth misbehave more, but that the behavior from certain groups is viewed more harshly, that is punished more harshly. And when we consider that over 90% of the teachers in Pennsylvania are white, we have to consider that how implicit and explicit bias plays a role in who's punished for what behavior. So who's seen as being disorderly, who's seen as, creating a disruption or being insubordinate. And there are a number of things that schools can do to address conduct issues, right? They can implement trauma-informed approaches with students. They can implement implicit bias training for teachers and invest in more social workers and counselors, things that One Pennsylvania has been pushing for a while. Schools can also implement a pre-arrest diversion program, similar to the one that started in Philadelphia. It's been highly successful. By year 4, they had a 71% reduction in arrests, and they had low rates of recidivism, with 86% of youth still arrest-free after completing the program. And generally what's involved is that when a youth is determined eligible for the pre-arrest diversion program, a police officer and somebody from the Department of Human Services visits the family and the youth to see what their needs are, what services they can provide for them, what supports are available, and ask them if they want to be a part of this diversion program as well. And these are things that schools can do too. They can implement some of these policies, some of these programs. They can do mindfulness. They can do other things in the program that help in the schools, that help students before rather than reactionary, and understanding that reactionary is also, mostly to very minor offenses as well. Then I talked a little bit more about the fines and the fees, about placing an unnecessary burden on families, particularly for children. And essentially, when we are doing things like a failure to comply charge, so if a student is issued this summary citation, say, for obscene gesture or for disorderly conduct, and then they're issued a fine by the magistrate, and they are unable to pay that fine, what they get charged with is something called a failure to comply, and that gets referred to juvenile justice. Right, and that is 1/3 of all of the referrals to juvenile justice in Allegheny County. It's over 18% for the entire state. It is almost double the, I think, the next offense category in terms of what students are referred to juvenile justice for. And so when we do this failure to comply, what we're doing is we're punishing poverty. Right, we're punishing this inability to pay. It's not teaching children anything. They're not learning anything from these fees and fines. And so that's definitely something where in the recommendations would make a huge difference, because the summary citations, they look like minor tickets, right? And so it's easy to ignore them, but they stay on your record. They can impact you if you're applying to college, if you're applying to the military, if you're applying to different programs. That shows up on your record when you have to answer, have you ever been convicted of a crime? You would have to say yes. So it's not just a minor thing. It's a pretty major issue for kids that can follow them for a number of years, if not their whole life.
Thank you for that, Brandi. Do you have any thoughts or any reflections before we go to Cheryl? You're on mute right now. No problem.
Sorry. It's just, difficult to grasp that we even have to have this conversation and we're talking about children. And I'm hoping if, nothing else, when people walk away from this, that they see not just a serious need to make change, but also, the reason why advocates advocate so strongly for systemic and structural changes, because a lot of this is embedded in the way that institutions are ran. And so a lot of these things are embedded within school discipline policies. And so families tend to think that this is just the way it has to be because it's the way that it's written in school code. And so, we do have the ability to make changes to these things. I'm excited that the task force is a statewide task force, because it's very difficult to go school by school by school to try to make these changes, and appreciate you all. But just having, the audience keep in mind that we are talking about children and that these things are ruining their lives. As Gada pointed out, this follows them. It's difficult for them to get in college, to get in much needed programs that will help better their life. And at the end of the day, the fines, if you're talking about young people and children, who is that on ultimately to pay, right? Even though it's in the child's name, they don't have a job. It's ultimately on the parents to make this payment, but the child is still penalized at the end of the day.
Right. Yeah. I just want to thank all the panels. I think this information has been, really powerful, really centering young people. And, when we talk about policy a lot, oftentimes it becomes word salad of, $2 words, with 8 syllables. But, y'all are really, bringing kind of the flesh and bone and blood back into the conversation, about what this is about. So I really appreciate it. And for our final presentation, before we open it up for question and more discussion, we have Cheryl Kleiman from the Education Law Center talking about school placements and school stability issues, as they call them.
Yeah, I just really want to echo all the points that have already been made, recognizing that schools should not be a basis for children to enter the juvenile justice system. And even when children are referred, it doesn't mean that they need to be removed or should be removed from their home. So yeah, children should not be in placements. Like that's our starting point. And so the points that I wanted to emphasize is when a child is in placement, it's important to know, and I think it's a common misconception, that children who are in a placement no longer have a right to attend public schools. And that's just not true. There's currently a rule that says very clearly that children in placement have a right to attend public schools, either their previous school that they were in at the time they were removed from their home, or the public school that is closest to the placement they're in. So this is already in right that children have, and unfortunately we know it's not a right that's a reality in many situations. And so one of the recommendations that we're supporting is that this becomes law by statute, and that the legislature enact a statute making clear that children who are in placement have the right to attend public school. If children are in placement and then are not able to attend public school, it is equally important that they have access to a quality education within placement, which, to be clear, is absolutely not happening right now. Children should be given live instruction by certified, qualified educators. Currently, they are getting packets or worksheets, if at all. In the pandemic, we've also hearing that even that access has been limited. And of course, children with disabilities, children that have other English learner or other education needs are disproportionately not having their needs educationally or otherwise met in placement. And so while we would want no child to be in placement, if they're there, they are still entitled to that quality public education that they should be receiving. And then finally, we know even when children finally get out of placement and are returned to the community, that then they face additional barriers in returning to public schools. So again, this is an example where under the law, it's clear that a school cannot automatically deny a child access to the regular school because they're returning from a juvenile justice, a foster care, a mental health, any sort of residential placement. But again, this happens all too commonly in practice. So it's really important that we support families in understanding their rights to push back when their children are being denied access to an education, but we can't place that burden on families. It's really on all of us and the folks in the system to make sure that those rights are realities for children.
Thank you so much, Cheryl. Before we do go to open Q&A, I just wanted to ask Leola if you could just expound a little more on the age of jurisdiction for juvenile being raised from 10 to 13. Can you just talk about that just a little more so people can understand? Because I think a lot of times when people think about juvenile justice, they think of 16, 17-year-olds automatically. And we're talking about, this age of 10. Can you just explain, how the current system is when it comes to juveniles and placement and ages and what that means to raise at 13?
Yes, Brandi. Currently in Pennsylvania, under the Juvenile Act that governs criminal justice within the juvenile with children, the minimum age that a child can be charged with a crime is 10, with everything except for homicide, where there is no minimum age. So you could be 6 or 7 and be charged with homicide in Pennsylvania. But for any other crime, large, small, the minimum age is 10. One of the recommendations of the Pennsylvania Task Force is to raise that age from 10 to 13. So before I expound on that a little bit more, I want to go back to, you use the word placement, and we've been using that word placement. And I just want to make sure people understand that there are so many words that are used within the juvenile justice system that really makes it seem like that's not so bad, right? We use the word placement when someone is in a placement, they're a resident, they have a bedroom, and all of those things. However, many of the placements, especially the state placements, many of them are just like prisons, adult prisons. So you have to remember, when kids come into the system, they're treated the exact same way. They're handcuffed, they're locked in cells. We have kids who are strip searched. I have one female girl client who just breaks my heart thinking about it, who is 16 and talks about going to a state placement, and she didn't want to take off her clothes. And 2 workers there took them off for her. And just like an adult, she had to bend over and cough. So these are things that happen to children. When children in Philadelphia have to go across the state to a state placement, they're taken in shackles. There are no bedrooms for the secure facilities. They're cells. They're locked in cells. So you think about a 10-year-old coming into the system, a 10-year-old being taken away from their parents, arrested, put in a cell while they're waiting to be processed. Whether you're 10, 11, 12 years old, can you imagine the trauma that can have on a child? So that's just the backdrop of it. And when we think about some of these task force, we had a task force in Philadelphia, and really it came out of the horrific abuses that have happened to children, not just within the delinquent system and placements, but also in the dependent system, in the child welfare system. David Hess was murdered at Wordsworth. When you think about Glen Mills being closed, Glen Mills was closed because of our office, because finally they had cameras at Glen Mills after years of not having cameras, and one of our clients was abused and assaulted on video. It's when you watch these things that happen to children, and we fight each and every day for each of our kids, fighting for videos, incident reports. We get blocked on so many levels, but we are tenacious. And so we usually get what we need to get. And we have stopped sending our Philadelphia kids to many of the placements around Pennsylvania because we just do not feel that they're safe. And if I don't think that they would be safe for a child, I'm a mother myself of a Black girl and a Black 14-year-old boy. I'm not going to stand there and allow them to send other kids there, at least not without a fight. They're going to have to get through me first. So going back to the 10-year-olds, my belief is 10-year-olds are not competent to go to trial. So not just in terms of placements being jail-like and all of those things, kids have the same rights as an adult when going to trial. They have to make decisions that can affect them for the rest of their lives, can affect their ability to get jobs, go to certain schools, have different career paths. Can you imagine talking to a 10-year-old about the pros and cons of one defense over another? Should you do an admission, which is a guilty plea, or should you go to trial, and explaining all of the consequences? Because of that, within our unit in Philadelphia, I decided we're going to have competency evaluations ordered on all of our kids 13 and under. Because my feeling is they're just not competent. They don't understand what is going on enough to be able to participate in their defense. And so I don't think that they should be treated the same way as some older kids. So we've been doing that for the past 2 years. I would say about 85 to 90% of our 12-year-olds and younger have been found not competent by court psychologists. And I think that is significant, that we need to follow the science with this. We know about adolescent brain development. When you know better, you do better. Children who are young just do not have the capacity to understand what's going on. That does not mean that there's no accountability. I feel that their needs can be met within the child welfare system if needed, and services can be put in place for those children and their families in order to have some sort of accountability. But making them make decisions that are going to affect them for the rest of their lives is just ridiculous to me. You can have a 10-year-old who believes in the Easter Bunny. How are they going to make a decision about going to trial? So with the current recommendations, I guess as a compromise, they want to do a carve out for certain charges. So they're saying that the idea is raising the age to 13 for all charges except for sexual charges, which would be felonies of the first degree. Felony of the first degree rape would be an example of that. At first blush, you're like, rape, maybe I can understand that. Until you really look at what is being charged as rape with children. In my practice, I have not had a 11, 12-year-old charged with rape of out on the street with some unknown person. Most of these charges, number one, are overcharged by the DA, right? And most of them are inter-family situations, which really need to be, in many cases, can be handled within the child welfare system. And in many cases, families want them to be held within, the child to be held within the child welfare system. What we have now is a very adversarial situation where kids really are not getting the help that they need, who are charged with these kinds of offenses. Also, it really shows disparity, especially racial disparity, because the carve out would allow for DAs to overcharge children in order to bring certain children into the juvenile justice system that wouldn't ordinarily do that. And there could be disparate treatment depending on the DA, the child, the jurisdiction. I just don't think kids who are 12 and under are competent to go to trial, and they should not be made to make decisions that can affect them for the rest of their lives. I think that there needs to be accountability, but I think there are other ways to be accountable with kids who are that young.
I know God, I had a follow-up.
Yes, thank you. And I just kind of a little blown away by some of the things that you've shared. I will say that when we're talking about the age, obviously we're talking about the minimum age for a child to be arrested and adjudicated delinquent. With summary citations, there is no minimum age. And so I have seen instances where in Pittsburgh, a 3 and a 5-year-old were issued a summary citation for fighting, right? So there is no age limit, and police officers giving a 3 and a 5-year-old a summary citation for fighting, it just doesn't make any logical sense. So these are the types of things that need to be addressed. And this is one step closer to that. These recommendations are one step closer to addressing some of these issues.
Khari, can I just say something real quick?
Please do. Please do.
So one of the things that I think is really critical is that for those of you who are thinking of commenting or writing, is that many of the requests out of especially the dispositions, so the sentencing subgroup and the pretrial subgroup, are that these things become part of the Juvenile Act, part of the law. And the pushback has been that people want discretion, police officers want discretion, judges want discretion, prosecutors want discretion. So therefore we should not make it law. We should just issue strong recommendations. And I think just that shocking example that Gada just gave of a 3-year-old and a 5-year-old, right? These are the types of outcomes that happen when people have discretion. The data that was presented to the task force is not new data. It is not unknown that these deep racial and ethnic disparities exist. It is not unknown that Philadelphia has a successful school diversion program. It's not a new program. It's been a national model, actually. But when people have been given the option, when people have been given the data and the option to do better, they have chosen to continue to disparately sentence Black and brown children to placement, to arrest when there was no need to arrest, to overcharge, to refuse to send children back to juvenile court who need treatment in juvenile court. And so it is really important that the recommendations remain strong and recommend a change to the statute, not just a request to judges or police officers or district attorneys to do something different, but to actually force them to do something different, since they have shown that they're unwilling to when given the data on their own.
Right. I just go ahead, Brandi.
Oh no, I was just going to say that, you know, me personally, I've always talked about the fact that people can go to jail when they're 18, like prison, but you still have to wait till you're 21 to drink. And I think that just goes to show, like, these people who are making these laws and making these rules don't always have the best interest or even know what they're doing, right? They're just like guesstimating on what should happen. And I use that as a very broad example because I think most people can understand, you know, I can be locked up in prison and face all of this, all of the things that go along with being in prison, but you don't think I'm competent enough to have a drink or handle alcohol, right? And so, you know, when we think about these things, when we're thinking about ages, and science tells us that our brains are still developing up until the age of 25, which means any trauma makes that even worse, right? It even slows that development down even more for anyone that knows anything about development. It slows that down even more. And trauma could even be, you know, bumping your head on something hard enough, or even environmental factors of trauma that you are living, any conditions that you're living in. And so, you know, just to give a little proper perspective, when we're thinking about over 80% of disorderly conduct being towards Black youth, when we know that racism is real, when we know that these people in power making these decisions don't always have the best interest at heart, especially for Black and brown people, and then we consider this issue of discretion. Discretion has never been used on the side, it often is not used on the side to help us, right? It's used on the side to harm us. And so, you know, making these type of things law, for someone to say that I want the option to be able to handcuff and charge a 3-year-old, a 5-year-old, a 10-year-old, for someone to say, I want the discretion to be able to do that is problematic in itself, in my opinion. And so, and I think that shows the character of people. I don't think anyone with a child, and even without a child who even cares about children, would think, I think it's okay ever to handcuff a 5-year-old, a 6-year-old, to charge a 10-year-old with a crime. Like, you know, when you're thinking about these things, if there's no room for growth and development. And even when we are raising our own children in our homes, you know, if we're saying, if the system is saying that it's abuse to use, you know, physical discipline, right? They're removing children from people's homes because their parents are doing or are using physical discipline as an option, but yet and still we think it's okay to throw people in jail and incarcerate them and put them in handcuffs and shackles. I mean, it just doesn't make any sense. And so I'm just hoping people are opening their minds while they're listening to this, because often, you know, the narrative that we are fed, we buy into, and the language that is used, crime, criminal, juvenile, you know, it detaches us from the humanity of the situation. And so we're really just trying to take this moment to bring this back, to center our humanity. And we're talking about babies, literally. We're talking about your children, and that we really need to take this seriously and get to this hearing on the 14th and make sure we sign up. Because I know I am. I mean, hearing these stories are very disturbing. You know, it's emotional. It makes you just want to cry. And, you know, thinking about young ladies and, you know, their body, I was always taught, you know, I was always very shy about my body. And to not have people, you know, even when you were swimming, when we were coming up younger and everybody's in the room, I always went into the bathroom to put on my swimming suit. Everybody was outside. And so there are people who have been in these type of situations, sometimes sexually assaulted when they're young. And to have to go through that process is extremely damaging and terrifying. And I just couldn't imagine. And so thank you all for being willing to tell the truth about what is happening in this system and giving people an opportunity to walk through those doors through your words.
Yeah, and I just had just a quick question, for the entire panel, and it's kind of, as a segue, from what Brandi talked about, you know, you know, so much of what you talk about to me from a policy recommendation standpoint seems like, a no-brainer, but, a number of special interest groups, keep coming up, whether it's some of the school issues that Cheryl talked about, or we're talking about, local law enforcement, or we're talking about organizations, such as the District Attorneys Association. So I just wanted to kind of, just for the group, because you talk a little bit about, the kind of impact that these special interest groups have on the process, that, groups that people might not think about every day. I think, people obviously are aware of their local district attorney in the county that they live in. But I don't think people necessarily think about this other entity, the District Attorneys Association, which is a whole different, entity, and, wields its power, in a way that's much bigger than a singular district attorney's office in, any of the 67 counties around the state.
So I think one thing that I think about is the fact that the sort of the pressure, the conversation has been that if we push these recommendations out of the task force, and there is going to be significant opposition from, for example, the District Attorneys Association, that, well, they're just going to go to the hearings, when the legislative hearings, and testify, and then the whole thing will fall apart anyway, because no one will vote for it if they're strongly opposed to it. And I think it's just another example of how we amplify certain voices and ignore certain voices, right? And so no one has ever said in the task force, well, if these recommendations don't go far enough, then citizens may choose to decide how they vote about the representatives or the senators who are opposing these recommendations, right? And so people are terrified of the District Attorneys Association, but they're not terrified of the power of the people. And I think this is an opportunity for us to turn that narrative on its head. People are afraid of the Chief Probation Officers Council, or whatever the state Chief Probation Officers group is called, but they're not terrified of parents and of youth who have actually been very vocal throughout this process. We've had several youth-led organizations be very vocal in speaking out. But it's another example of what voices we choose to validate versus the voices that we choose to ignore. And so I think we need to provide voices that are not able to be ignored or silenced on both April 12th in writing and April 14th in person.
Yeah, that's probably. Is there anybody else that wanted to touch on that? If not, then we can go into some final words from each of our panelists.
Well, I would just like to say I completely agree with what Tiffany is saying. I'm not a member of the task force, but I have been participating virtually with all the task force meetings. And in each case, you have people relaying worst case scenarios, in order to make their point. So they want to highlight something that may happen once in a lifetime in order to not make changes to things. And I think that we need to be cognizant of that when these stories are being told, well, what if this happens? Many instances, these are things that have not been happening or once in a lifetime kinds of things. And I think that is the wrong way to look at things. You don't make a huge net for a small fish. It just really doesn't make sense. So I think that people need to be vocal, and really some of the things all of the things that we've spoken about today really are not, they're progressive, but not overly progressive. I really don't understand the issues with, not charging a 10-year-old or making sure kids have quality education when they're in placement and have certified teachers, or not putting financial penalties on kids who can't even work or may be too young to even get working papers. I don't see how those things are really controversial. And I don't think they are controversial to the majority of people. So we really need to be, to have our voices heard, so we're not drowned out by a minority of people who are going to talk about worst case scenarios.
Thank you for that.
I'm sorry. And just to add, I think it was Goddard that brought up 1/3. Like if we're looking at these numbers, if people are using the most drastic 1 or 2 examples that they could find, compared to 1/3 of referrals into the juvenile system being fines and fees, right? We're just talking about criminalizing poverty. And this is almost like, a microcosm of this macro situation that we see when it comes to adults in the criminal legal system and just the American criminal legal system as a whole. And then it just reminds me, and this is where I wear my hat that is not always so popular, but it just reminds me of, how in back in slavery times when children were snatched from their families, right? And so people tend to think and ask questions and say, well, why would somebody want to treat young people this way, right? Like, why would somebody just want to be this way to a 5-year-old? There has to be something so egregious. But is there anything that you can think of that your 5-year-old can do so egregiously that you cannot sit and have a conversation about or find it being attached to some other issue? And then, it just keeps people in a system, right? And so we're talking about, this system being built on money and, capitalism and people worried about profits over people. This just signifies that. If you have a child and you're really trying to help this child become better, then if you're talking about discretion, the only discretion that you need to use is what is the proper response for this individual child, as far as what type of help do we need to develop for this particular child, their situation and their conditions. And so, the discretion is never on the side of what is the best help, but it's, it's always on the side of what is the least amount that we can do criminally. What is the least amount that we can do that we're going to benefit from? And that's what I need people to really think about at the end of the day. Why does this exist? Why are we talking about this tonight?
Right.
Why do we have to fight for this?
And I just want to say that within the criminal system, just like what you said, Brandi, we don't get to help the kid, because as that kid's attorney, I have to be concerned about protecting their constitutional rights. And there's so many times I have conversations with parents and they're like, this is crazy. Like we should be looking at, we want to help this child, but because it's an adversarial system, that gets lost. It gets lost. And I think that there are other systems available to provide accountability and intervention for especially our youngest of children, because the way we're doing it now, it's subversive in a way. It really gives a different result. And even if there is accountability at some point, it's so far after it happened. They talk about adolescent brain development with recency. Your child does something they aren't supposed to do. You should have a consequence that's pretty immediate so that child can make that connection between what they did and the consequence of it. But the way the system works, that doesn't happen. So it's really counterintuitive. And we need to reimagine a different system, because I fully believe that kids need to have accountability and there needs to be interventions in some cases, because we want kids to be safe, families to be safe, and communities to be safe. But we need to reimagine how we're doing it, because the current system just is not working.
I'm so glad we're sort of taking this moment to reframe a little bit, because I do think at the same time we're lifting up the importance of these recommendations, we need to be clear that these changes are not young people's vision for justice, right? Like, this is about harm reduction. This is about recognizing that currently, when a child is removed from their home, the state will check to see if there is lint in the dryer in the carceral placement that they're in, but not if they are given any opportunity to learn. And And so I completely echo the call to say, like, we are working to reduce the harms at the same time we need to continue to support community and youth-led visions for a very different system of accountability, for means of transformative justice, so that people can heal and all children have an opportunity to thrive. And these recommendations are not that, but that is where we are ultimately and collectively, our vision is of where we're going.
I wanted to say something to Brandi's point about profit over people. And the thing is, actually, it only profits a small segment of people. We as taxpayers pay more for policing. We pay more to jail our youth than we do if we were to invest in preventative measures. And in fact, if we were to support children, right, we would have, and adults as well, right, we would have thriving communities. It would actually be better for our economy as a whole, right? So it's not something where we say, oh, this doesn't concern me, right? Like, I don't have kids that are going to be impacted by this. I don't think that I'm good. It impacts all of us. This whole system impacts every single one of us as a taxpayer, as a member of our community and in our city. Everything that happens with youth, with adults, the whole system impacts us. And so we have to think of it that way too. This is an investment in our future, right? This isn't a separate issue. This is an investment in our community and in our future.
And I think that is like a perfect segue into how we end this, is because it all comes back to the money, right? And what has the cry been is to divest out of the carceral system and invest into people and their communities.
Absolutely. So now let's go for Cheryl, Gada, Leola, then Tiffany for final comments.
I mean, I think we laid it on the table. Like, I'm just so grateful to be here. Please don't hesitate to reach out to the Education Law Center if you want some more support about understanding what your child's rights are in school, in the carceral system, but in all of public education. And I'm grateful to continue to do this work with all of you.
Thank you so much.
I mean, I think I would echo a lot of the things that everybody said, but I would highly recommend that everyone, at the very least, submit written testimony, even if you can't publicly comment. It doesn't take a lot of your time. I mean, you can base it on what you heard here today, and just submit it by Monday. And I appreciate being here. Thank you.
You're on mute, Leola.
Thank you for having me this evening. I think that we did bring it full circle, and so much of this is about the money and reinvesting in our children and our families and our communities. There's so much money that is being spent to incarcerate children. If we repurpose that money and put it into a fraction of it into the families, the children, into education in the communities, what a world we could have. And I really think that we need to reimagine the juvenile justice system. And I encourage everyone who is listening to sign up for either put in written testimony or sign up to give verbal or oral testimony, especially young people. If you've been part of the system, I really ask that you consider doing this to give your perspective on what you liked about the system, what you didn't like about the system, and your feedback on these recommendations. I think that is really critical. And again, thank you.
Thank you for this amazing panel with these amazing women to talk about these issues. I don't want people to get put off by the word testify. People come and they say their piece, they share their experience. This is not a scary process. No one's gonna sort of give you Q&A or critique or criticize anything you say. We truly just want to hear from you. If you want to write, no one's gonna be looking for grammar or spelling errors. We just want to hear from you, and we want to hear your message. And we're asking you to make the community's voice the last word in this process. They have created this final comment period with the hope that maybe someone else's voice will be the last voice, but we know that you can have the last word in this process. These recommendations are truly the very most basic things that we can do for our children, and we're just asking you to join us in the process. And thank you so much.
Thank you. And I want to thank our entire panel, Cheryl, Gata, Leola, and Tiffany for joining us tonight. Thank you so much for such a wonderful conversation. And for the final parting shot, I'm going to hand it over to Brandi from APA. And also thank you to 1PA and APA for inviting us to be a partner in this very, very, very important conversation. So to close this out, Brandi, it's on you.
Yeah, just please sign up. Hopefully we're dropping the link again. I know our organizations will all be sending out e-blasts to our list to let you, so you can have information that you need. We'll be sending out the recommendations if people want to take the time to read them over. We'll also be sending out some talking points just to highlight some certain things so you're not overwhelmed when you do sign up to speak and you actually do go to speak. So we'll be sending out e-blasts to give you all of that information. And feel free, these are people that do this work every day on the ground. So reach out to any one of us if you are having problems in school with your child, because you do have rights.
Absolutely. So thank you everyone for joining us. Again, thank you to our panel for joining us. And remember, please sign up before Thursday. If you can't sign up before Thursday, send in written testimony by Monday, April 12th. So thank you so much for joining us. Until next time, stay safe and stay engaged in the process. Good night.